before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-7160, Alexander Khochinsky, Appellant versus Republic of Poland, a foreign state. Mr. O'Donnell for the appellant, Ms. Moore for the appellee.
Good morning, Mr. O'Donnell. Mr. O'Donnell, proceed whenever you're ready.
Good morning, Your Honor, and may it please the court. I am Nicholas O'Donnell on behalf of Appellant Alexander Khochinsky. Sovereign immunity is an expression of what the courts have called comity and respect among the nations, and the Foreign Sovereign Immunities Act, of course, codifies that framework. But underlying that policy and underlying the exceptions in the FSIA are those ideas of grace and respect. This case presents to the court a question of first impression in this circuit, namely, what happens when the foreign sovereign flouts that idea of respect? Because, make no mistake, respectfully, the disrespect among nations at issue in this case is Poland's bad faith persecution of Alexander Khochinsky in the United States. What then do we make of the first two exceptions that we've invoked in this case, the implied waiver and the counterclaim exception? First, as the district court noted, we are dealing with facts that are not in dispute. In moving to dismiss, Poland did not contest the underlying allegations, with which the court will be familiar, but it's important to remember. Mr. Kaczynski did not go to Poland and commit some crime. Mr. Kaczynski raised the prospect of restitution of his family's Holocaust lost or looted property. And in Poland, that's not allowed. In Poland, asking about Jewish property restitution is antithetical to the policy of the government right now. And so what happens to him? Poland initiates an extradition request, which results in his arrest in New York City and his imprisonment and the attempt at his extradition, which Judge Rakoff in the Southern District thankfully rejected as without evidence. So that puts to the court the question of what are we to make of this? And I think it's important to look right at Blaxland, the case from the Ninth Circuit on which Poland relies and on which the district court relied, because I think there's no getting around it. It presents this court with a fork in the road. As the district court noted, this court has been reluctant to find an implied waiver and all the good. But what do we do when a sovereign erects a purely pretextual and discriminatory prosecution against a person whom they seek to deport from the United States?
Isn't extradition an executive process, a diplomatic process, right? It involves the Department of State, the Department of Justice. It doesn't involve the Republic of Poland going to court itself.
Your Honor, that's how it begins. That's how it begins. And I think it's a critical point because even in Blaxland suggested that unless the foreign sovereign is engaged in the U.S. courts, that these exceptions don't apply. But the extradition doesn't, as we say, spring forth like Athena from the head of Zeus. The extradition happens because the foreign state goes to the State Department. And what should happen then, what should have happened here is someone in the State Department says, this is absurd. Of course not. But that didn't happen here. And unless the State Department and the Justice Department go to court, nothing happens because the State Department, doesn't pick up people off the streets. They have to go through the judicial process, and it only ends with the extradition of a person.
Perspective of the Republic of Poland, that process is a process that's internal to the United States, right? To satisfy due process requirements and other requirements, right? Our State Department, Department of Justice seek a certificate of extraditability. That's a process that's internal to the United States, right? It's not something that the Republic of Poland invoked itself. They're just seeking extradition. They didn't go to court themselves.
They did not go to court themselves, Your Honor. That is right. But it is the first link in a chain without which there can be no extradition. And I think the perspective that the district court took, the perspective that Blaxland takes, loses the forest for the trees. And in this case, not coincidentally, there is some back and forth. Judge Rakoff poses some questions to the Justice Department. The Justice Department gets the answers as a pure pass-through. The Justice Department doesn't mediate anything the way Blaxland suggests. They pass the question to Poland. Poland provides the answer. That's participating. And again, I can't do this. A foreign corporation can't do this. The only ones who can do this is a foreign state. The only ones who can invoke the extradition treaty is the foreign state. But once they do, and again, on the facts here, for purely illegitimate and discriminatory reasons, then there can be consequences. And as I thought about this argument, I thought, of course, this treatment of Mr. Kaczynski profoundly unfair. But take an even more extreme example, right? Imagine the United States has extradition treaties with almost every country in the world except Iran, Syria, North Korea, I think maybe Cuba, right? Imagine the Taliban reassume control of Afghanistan, and the Taliban institute prosecutions purely of facially recognizable crimes, but purely for religious discrimination against Jews, against Christians, whomever. Okay, and as here, nobody at the State Department stops this before it gets to court. That will be okay under the perspective that Blaxland and the district court compel.
That's a question. If we reach the conclusion you do, would that mean that anytime the U.S. makes an extradition request abroad, that it ought to be prepared to have been deemed to have waived its sovereign immunity and subject to suit?
No, Your Honor, and I think that's an important point because, first of all, nearly every extradition request, it's important to remember, will result in extradition, right? The conclusion here in the district court is extraordinary in the usual sense of the word. The district court judge looked at this and said, no, this doesn't add up. Even then, even if the same standard were applied to the United States, even then, if the United States were faced with a claim like ours, or as Poland was here, they can contest my allegation that there's nothing to this, my allegation that this was a pure invention. And at that point, then I have to prove what I'm saying at the threshold stage, right? So this is an enormous guardrail against that concern. And then, even then, of course, like I said, there has to be the discriminatory and arbitrary nature of it has to be plain on its face.
Right, but you would have waived, but there would have been a waiver of sovereign immunity. It's true that the extradition can be stopped, as it was here, but by dint of asking for the extradition, it opens the door to waiving sovereign immunity for anything that arises out of the extradition, any claim that arises out of the extradition request.
The request, Your Honor, what I'm saying is, the problem is, of course, I'm putting the cart before the horse in some sense, but the claim has to exist. What is the claim? The claim here is that the prosecution abroad was for discriminatory reasons. So yes, what I'm saying is, once Poland sets into motion that prosecution requesting the extradition waives the sovereign immunity, yes, but that's what happened in Sitterman. And I think it's important to look at Sitterman and Blaxland in connection, and I suggest respectfully to the Ninth Circuit that Blaxland and the district court in our case relied on a distinction that is really without a difference. That once the foreign state reaches into our judicial processes, and it may be by filing a paper, it may be by filing an appearance, it may be by sending a letter rogatory, it may be by initiating an extradition process that it knows will lead to a certain conclusion, that it's done so. And that's what the implied waiver is about. That's what the counterclaim exception is about. The counterclaim is about, the phrase is, brings or intervenes in an action. And as the Lord Day case held, even that language, that plain language, we're just looking at the statute, not the legislative history, that applied to an interpleader action. The statute doesn't say interpleader. And you could take an extremely narrow view and say, well, if it doesn't, isn't intervention under Rule 19 or filing of a complaint, initially it doesn't count as brought or intervenes, but Lord Day expanded that perspective, and we think appropriately so. With that, I'll reserve the balance of my time unless there are any other questions.
Thank you. We'll hear from Ms. Moore, and then we'll give you your rebuttal time.
Thank you.
Ms. Moore?
Thank you. Your Honors, and may it please the Court, Desiree Moore on behalf of the Republic of Poland. The District Court's order granting the Republic of Poland's motion to dismiss should be affirmed. The Republic of Poland is presumptively immune and is in fact immune from the jurisdiction of this court, and no exception applies in the present matter that would withdraw this immunity. More specifically, the entirety of Mr. Khochinsky's claims center on an extradition proceeding that occurred in 2015. The extradition, irrespective of how it is characterized or cast, does not give rise to any exception to the immunity that Poland is otherwise afforded, including under the implied waiver exception or the counterclaim exception that Mr. O'Donnell mentioned today. I'd like to pick up where Mr. O'Donnell left off, if I could momentarily. Mr. O'Donnell encourages a dangerous precedent, and Chief Judge Srinivasan, to pick up on your question, the answer is yes, and Mr. O'Donnell concedes this. The United States would be subject to lawsuits around the world anytime it initiated extradition pursuant to a treaty among nations. That is counter to the concepts of comity and respect among nations that Mr. O'Donnell started off with, and in fact would create chaos and would discourage what the extradition treaties are intended to allow, which is this respect and
Ms. Moore, what about the argument that by seeking extradition, the Republic of Poland knew that there would be a judicial process in order to complete its extradition, right? Although, of course, it went through diplomatic channels in order to actually extradite Mr. Kaczynski, there would have to be some judicial process. What about that argument?
Sure. What Mr. Kaczynski is complaining about, in essence, is the process itself. So the extradition statute contemplates that once the State Department passes the kind of preliminary evidence to a magistrate or other district court, there is a judicial component, and Poland, in accordance with the extradition process, provided evidence. Absent that evidence, you would never successfully extradite anyone. So it's not improper on its face to adhere to what the statute contemplates. And there is a judicial component. And Poland's knowledge of that judicial component does not bear on whether the extradition process is proper or whether, more importantly, the Republic of Poland has acquiesced in the jurisdiction of the United States courts.
Why isn't there an implied waiver by invoking this process?
So courts have universally found that the implied waiver exception is narrow. It is narrowly construed, and absent strong evidence that the foreign sovereign intended to waive immunity, courts will generally not find that there is a waiver. The legislative history talks about an agreement to arbitrate as a potential indication of waiver, where the foreign sovereign has agreed to a particular choice of law, or where the foreign sovereign has entered a responsive pleading without raising jurisdiction. And while the legislative history indicates that that might not be the entire universe, there is a commonality there. The foreign sovereign has to demonstrate an intention to waive in order for that implied waiver exception to come into play. And here, there was no such action taken on the part of the Republic of Poland.
In extradition, I just have a background question about how it actually works in practice. If a foreign country asks for extradition and then the executive, that goes to the executive here, and then the executive makes an assessment of what to do. Does the executive typically exercise discretion in determining whether to pass on the extradition request? In other words, it's engaging in its own inquiry, and then it makes a determination of whether to accede to the foreign government's request for extradition?
Yes, Your Honor, I believe that's correct. The State Department makes a preliminary determination before then passing the inquiry to a magistrate or a United States District Court judge for essentially an evidentiary analysis of the evidence that was put forward.
So in terms of the nexus between the foreign country's request and the judicial proceeding that ultimately ensues, it's not that the foreign government is necessarily saying, I'm subjecting myself to a judicial proceeding. What it's saying is, I'd like your help. You put yourself in a judicial proceeding at my request. Definitely, I'm triggering it. But at my request, I'm asking you to subject yourself to a judicial proceeding that then will pass on the request that I've made to you.
That's correct, Your Honor. And on the face of the caption in this particular extradition hearing, the 2015 extradition that Mr. Khochinsky's entire complaint is based upon. The caption itself is the United States versus Mr. Kaczynski, and an AUSA shepherds that proceeding. So that's correct, Your Honor.
I think there are certain things that have to be examined by the executive, such as whether the dual criminality standard has been met and whether there's an adequate foundation in the evidence.
Correct, Your Honor. And I think that that's further to the point. There is some level of executive discretion or executive analysis before it is transitioned to a judicial process.
I also find that there are also instances in which the executive has to, when the United States is requesting extradition, sometimes the foreign state will, depending on their laws, condition extradition on an assurance that there'll be no capital punishment or charge. It's a negotiation.
Correct,
in that respect, it's a negotiation between nations.
That's correct, Your Honor, and is exemplified by the fact that it originates and remains in the executive. It is a function of the executive branch.
Your Honor, go ahead. Sorry, Naomi, please.
So, I had a question about willfulness with respect to the default here. I mean, some of the claims of Mr. Kaczynski really are about what the government of Poland is doing here, right? And so I guess I'm wondering if you can maybe share with us, why the Republic of Poland is pursuing Kaczynski for a painting of relatively limited value, and whether that pursuit does suggest bad faith or willfulness with regard to the default.
So as it concerns the default under Rule 55, for good cause shown, the district court will reverse the default or vacate the order of default, or the entry of default rather. And the willfulness component goes to whether the Republic of Poland willfully did not appear, or whether there was some underlying event that can be pointed to that would suggest otherwise. Here, there was confusion as it concerned service, and I struggle to understand how the extradition or any of the kind of events that occurred in the aftermath bear on this. Mr. Khochinsky failed to effect service. Mr. Khochinsky emailed the Portuguese Central Authority instead of the Polish Central Authority at the outset. There were a number of sort of confusing events that occurred, and once Mr. Khochinsky did, in fact, proceed according to the correct process, certificate of service was service rather was accomplished thereafter relatively quickly. So there is no willfulness that Mr. Kaczynski points to, and certainly the court did not abuse its discretion in finding that there was no willfulness, or rather that there was good cause shown to vacate the entry of default.
Ms. Moore, if we disagreed with you on that and remanded the matter, well, I think that would result in remanding the matter. What would happen then?
In a sense, we would be back where we started, because without jurisdiction, the court cannot hear this case. And so that goes to the element of plaintiff's prejudice, even whether the case is remanded and whether we sort of start over because of that lack of or because of a willfulness determination, let's say. In any event, we are right where we started. Absent jurisdiction, a court cannot hear this case. Here, the district court... Has
the plaintiff alleged any prejudice?
The plaintiff has not alleged any prejudice that as contemplated under Rule 55. And where the court lacks jurisdiction, the plaintiff cannot be prejudiced in any event. And so, to your question, that there really is no prejudice here. Absent jurisdiction, the court cannot hear this case.
I have one question on.
The district court correctly found.
I have just one question on an exception that we haven't talked about yet, which is the non-commercial tort exception. So, just out of curiosity, I know that the action in the district court and in the briefing here has been on 1605A5B and whether the claim involves abuse of process. I'm just wondering whether there was any consideration given in the district court, before the district court, about the applicability of the discretionary function prong, which is 1605A5A as opposed to 1605A5B. Did that ever come up? And if not, why not? Maybe there's an obvious answer.
Your Honor, that did not come up, and the answer there may well be, and we would submit that 1605A 5B is the more pertinent exemption or exception to the exception, particularly where Mr. Khochinsky has pointed to abusive process as count 5 of his complaint, and the additional causes of action that he suggests are covered by the non-commercial tort exception, First Amendment retaliation, and tortious interference arise out of abusive process and are also barred.
But that may well be right. I'm not suggesting that it's not right. I'm not suggesting one way or the other. But is there an obvious reason that the initiation of the initiation of the extradition request was not a discretionary function?
I'm not sure, Your Honor. I'm not trying to understand the question in terms of whether there's an obvious reason. I think here, I'm not sure why the district court didn't go there, and we didn't raise it in our briefing because A5B felt like the more obvious and sort of pertinent exception. Apologies if I'm misunderstanding the question.
No, I was just wondering if either of them would work for your purposes, A5A or A5B, and I was just wondering whether there was an obvious reason why A5A was not a home where your argument could have been made, but it's not something central to the case, I understand, because it hasn't been litigated under that prong of the statute. Okay.
Thank you, Your Honor.
Unless my colleagues have further questions, I think we'll give Mr. O'Donnell his rebuttal time.
Thank you, Your Honor.
Thank you, Ms. Moore. Mr. O'Donnell, please.
Thank you. To cover a few things that came up in responsive argument, Poland, I think, now has conceded that there is judicial process. A lot of their argument rests on the idea that there was none. And that's really all we're talking about on the threshold matter, certainly of the counterclaim exception. With regard to Poland's response to the complaint, service in October of 2018 was proper. Poland conceded this. The sole email by my service provider as a follow-up to a Portuguese diplomat delayed the matter by 2 weeks before he corrected the address and followed up. As to the willfulness, there can really be no doubt, and again, on the allegations of the complaint, what they then did was arrest my client in France. And that leads to my final point, which is just the relevance of the European judicial decisions is Poland has been cast out of the European community as a country that respects the rule of law. And they are using this process there. Other courts have recognized it. We respectfully ask this court to take note of those decisions as well.
Mr. O'Donnell, if we disagreed with the district court as to the vacating the default judgment, what good does that do you?
The default, Your Honor, we would. There are two questions, of course. The question is, should default judgment have entered? We moved for it. The court turned us down. So the court could overturn the district court's vacating the default and remand with different instructions about entering default judgment, or the court could affirm the denial of default judgment and remand the case to begin and compel a responsive pleading from Poland, at the very least.
Aren't you, isn't that a bootless matter if you don't have a claim of prejudice?
If we don't have a claim of prejudice, Your Honor, that is a component of it, yes. And I submit part of the prejudice is we were entitled to the judgment, and in a collateral action is what happened in France. And rather than focus on this case.
Wait a minute. What's the claim? Ordinarily, a claim of prejudice in a context like this means that something changed during the period that the judgment was in force, or in this case, the default. And some development, some problem with evidence or witnesses, nothing like that.
In that case, Your Honor, no, that's right.
All right, thank you.
Thank you.
Thank you, counsel. Thank you to both counsel. We'll take the case under submission.
Thank you.
Case number 19-5204 et al. In re Navy Chaplaincy, Chaplaincy of Full Gospel Churches et al., Associated Gospel Churches Appellant versus United States Navy et al. Mr. Schulcz for the Appellant, Ms. Soni for the Appellees, U.S. Navy et al.
Morning, counsel. Mr. Schulcz, please proceed when you're ready.
Thank you, Your Honor. I may please the court. I'm Arthur Schulcz. I represent 54 chaplain appellants and the Associated Gospel Churches. I reserve 2 minutes for rebuttal. The Appellees hereafter of the Navy has greatly simplified this case by failing to respond to two of the major issues that the chaplains raise. And the precedent is very clear that if when a party fails to respond to a major issue, that is waived. And I can provide specific citations if the court is interested that shows that that applies to both appellants and appellees. I want to emphasize that the boards that we're talking about were composed mostly of chaplains, with the exception of one line officer. That procedure changed in fiscal year 2003 after we filed suit, challenging the stacking of boards by denominations unfavorable or hostile historically to my clients, and the practice of always having a Catholic chaplain on every board for 54 years with the power to essentially destroy the career of any chaplain for any reason at all. The first conceded issue is the fusion of civic and denominational responsibilities on power that results from the commissioning of clergy as naval officers. Larkin versus Grendel's Den pointed out that the core purpose of the Establishment Clause is to prevent the fusion of government and religious power. The Navy and the other services address that issue by restricting chaplains to only religious issues, only to ministry. They cannot perform the duty of any other officer. And the question has been asked but not answered, why then, if they restrict chaplains to from the duties that performed by every other officer, do they allow a chaplain to destroy the career of any other chaplain anonymously and without accountability?
What is the record evidence on the destruction of careers? You've pointed about, it says, for another point you were making, you noted that somebody who had been passed over in the Navy was hired by the Army.
Yes, sir. He 4 of them to be exact, Your Honor. Their careers.
What is there about destruction of careers in the record?
Your Honor, those chaplains, the chaplains of full gospel churches, their Navy career was terminated. They were hired by the Army, but they have to start all over again. So they start out considerably behind their other peers. And plus the fact is that's a violation, as I call the court's attention to 1642, the Joint Appendix, which is the machine. And I'm holding it up here so there's no doubt, if you can see this. If you press the 0 button, the undisputed testimony is that destroys the chaplain's career. No record is kept of who does that, nor it. And it's the equivalent, Your Honor, if you're on a panel, one of you judges can say, well, I'm going to press this button and I decide the case. It overrules the opinion of all the other people on the panel. The panels there are made up, or supposedly, of other officers, and so what happens is essentially no record is kept of this. This is the unbridled power that's demonstrated, and Chaplain Black, who was then the chief of chaplains in an investigation of that exact happening, described in detail this process called zeroing out. You press the 0 button and that person's career is over. And the particular complainant in that case, Mary Washburn, complained, and she was zeroed out because the female Navy chaplain disagreed with Washburn's view of ministry. Now that's a theological issue. And the requirement under fusion and under the Establishment Clause is that when you grant discretionary civic power to a person defined by their religious identity, there must be effective guarantees. Let me say it again, effective guarantees that the power delegated will be used for secular, neutral, and non-ideological purposes. And the record shows that is not the case. That this process, again, which I'm holding up, you press the 0, that can happen for you can do that because you don't like him, because somebody checked you out. And that's shown in the case of the 97, 98 boards. The other thing that the Navy has not disputed, again, is the testimony of Rear Admiral Black, Washburn, or any other, Rear Admiral Holderby, when he admitted to the Naval Inspector General investigating 97 and 98 boards, on which some of our clients, my clients, were participated. He testified that he, as the chief of chaplains, would influence other people because of his rank and the fact that he's the chief. He controls the careers of everybody on that board, with the exception of the line officer.
Mr. Schultz, what did you have to say about Washburn?
Washburn was a female, and she was a conservative, and if I can use that term, in terms of her theology. She had a conservative view of women in ministry.
And so but her complaint, as I understood it in the affidavit, was just that pardon me, that I think she referred to one of the members of the board as a feminazi.
That's
and herself as a conservative, right?
That's correct.
Right, I'm not sure of the relevance of that, but tell me this: what about the Black affidavit? That was just hearsay, right?
No, sir.
I thought she said that she heard about somebody who had heard from somebody else.
Sir, Your Honor, the Black affidavit, he's testifying to what happened on the board. He said he became aware that somebody was zeroing out Washburn because of the excellence of her record.
He became aware of it. So what does that mean?
Well, that's a question. It means nothing because it continued. And there is no way to stop
what does
that.
it mean to say I became aware of it? Does it mean he saw something, he inferred it, or he was told?
Your Honor, I think he looked at the results.
So he inferred that from the results?
Yes, Your Honor, let me give you an example. Okay, if you have 5 members on board and everybody votes 100, or 4 of them vote 100, and 1 votes 0, the most you can get is 400. So it's obviously something is wrong. And he called his attention. He said he called his attention to it. He had said this is a problem in the Navy, and he was going to the Navy Chief of Personnel. Washburn said she'd been on at least 6 boards. So this is not a simple, isolated, one-off incident. This allows denominational preferences. When you go to the 97 and 98 board, again, there's evidence there that clearly Admiral Holderby said he could influence junior chaplains, and then he had admitted advocating for one of his own denomination based on a devotional he heard this guy give. That's a religious reason. It's not in the record, and B, there's no requirement to give a devotional at the grade of commander. You have other evidence in that where Chaplain Madden went up. It says he had to go up above the board. He had to go above the zone to get 2 Catholics because nobody was else there. And the investigator for the Navy looked at those records and said, there's something wrong here because these Catholics have terrible records. And Holderby admitted that a chaplain with a perfect record was not selected because of, quote, the needs of the Navy. Now, there's no need in the precept for say we need Catholics priests.
You know, I think you're telling us about something that we decided already some years ago.
Your Honor, I'm not sure I understand.
Law of the case.
Your Honor, the law of the case is determined by Larkin and Grummet. Grummet says when the power is delegated to an individual specifically on the basis of religion, that's fusion. And in this case, you have to have a chaplain on the board. The statute requires that. And so the idea that somehow you can put off your denominational hat, so to speak, is absurd because the minute you take it off, the board is invalid. It's improperly composed. There must be a denominational representative on there. That's why definition of what is a chaplain, he's a denominational representative commissioned. And you have to answer the question, well, if you don't allow this chaplain to exercise the sovereign's power in any other issue, in any other aspect, why do you allow him in this, which the evidence shows destroys the chaplain's career? That's the exercise of power for a denominational preference, and the courts, Your Honor, must have the ability to examine, Grumman requires, says the courts must examine the process that arrives at a decision to ensure that the fundamental precept of the Establishment Clause, to make sure that one denomination is not preferred over another, is the rule of law. And all the investigations show that is not the case.
Mr. Schultz, could I ask you a question about standing for associated gospel churches?
Yes, Your Honor.
If we were to affirm the district court on the substance, would that require us to still reach the standing issues for AGC? Are there additional claims that AGC has that need to be considered on remand? And if you could just help me understand what those claims would be.
Your Honor, the AGC complained that the processes excluded its chaplains. If you look at exhibit number 472, it's a table. And this shows that this is based on the number of applicants that were rejected and versus the number of applicants that were considered. And if you see on there is those conservative churches like AGC are below 66%. And if you assume, because we're talking about people who meet all the qualifications, they've passed the minimum bar. And so if you assume if there's denomination doesn't play an effect or have an effect, then the acceptance and rejection rates would be about the same. They're not. And so that we're trying to say, why is that? And we believe, and there's evidence there that one of his chaplains, who was later actually hired by the Army, now rejected by them, he was asked, well, do you pray in Jesus' name? Can you do that? Well, of course you can do that. His faith requires that. And so the answer is yes. What you're trying to do is make sure that chaplains don't influence the decision based on theological purposes.
But are those claims for AGC different from the claims for the other parties? Like, do they have any, what are their unique claims that would require us to consider their claims separately? Or are there any distinct claims?
Your Honor, the distinct claims deal with the accession process primarily, but also they ask to be the representative of their chaplains. They have, at this time, there are at least 2 chaplains in the Adair case. There are 3 or 4 in the Larson case in which they joined. And so, yes, they want to represent their chaplains, and the district court said, no, you can't even be a representative.
No, but just
completely illogical.
If I can just follow up on Judge Rao's question. So you said that the accession claims are different. And just to be clear, even if we were to agree with you hypothetically that AGC has demonstrated standing, there'd be no reason to reach that conclusion if the merits of their claims are already resolved by the claims brought by other people as to whom the district court did find that there was standing. And so there have to be a reason to find that AGC has standing. And it sounds like what you're saying is there is a reason to find that they have standing because there's a category of claims, the accession claims, that haven't been resolved yet on the merits. That's what we're looking for. Are there claims by AGC that have not yet been resolved on the merits? Because if all their claims have already been resolved on the merits, then it doesn't matter that they have standing.
Your Honor, the answer is yes, there are claims, and those to do with the process by which you're assessed. I see that I'm past my time. May I continue to answer your question?
Yeah, you can answer. Yeah.
Well, what AGC wants to do is make sure that the process guarantees equal opportunity based on secular objective reasons why for a chaplain to be commissioned. We're not asking any of these things. We're not asking for some new special. We're asking for the same process. None of the other services have these issues. And so the issue is, why is this Navy different? And the issue is because they allow chaplains, denominational representatives, to make choices and decisions that affect the other careers. And this is under the Establishment Clause, unless you want to ignore Grumman. We've argued that Grumman controls.
But we've decided earlier it doesn't. Let me just ask you, follow up more specifically, Mr. Schultz. You said that basically AGC wants secular objective criteria, correct?
Yes, Your Honor.
But that was also true of CFGC, wasn't it? It was litigated.
CFGC was not litigated, Your Honor.
Pardon me. Was the question of having secular objective criteria litigated?
No, Your Honor, it's not been litigated.
Well, then how did the court, it seemed to me that was exactly what the claim was that the court rejected when it said about the constitutionality of the existing regime.
Your Honor, it said that that the criteria was in the Secretary of Navy's instructions. If you read those instructions, they don't talk about secular. They talk about subjective things like leadership. See, Your Honor, we're dealing with ministry, and that's our main point. They're evaluating but ministry is a religious.
Officers, right? We're also dealing with that. So you don't think leadership can be a valid criterion then?
Yes, sir. Yeah. But your perspective, let me give you an example. Chaplain Holderby looked at a chaplain from his denomination and said, gee, he gave this devotional. I'm really touched. He should be a commander. Now, that's a religious person. There's nothing secular about it. And this court cannot look at these decisions and say, gee, this is based on a secular reason. You can't do that. And what we're saying is its evidence shows that there are guarantees which are required under Grommet, and your ability to review them cannot be. And I will say, Your Honor, if the issue of fusion was not addressed by the court, you won't find that term addressed. They said, well, the issue is there's a standard, and those standards, the term that Larkin used is effective guarantees. And I would suggest that there's a great deal of difference, a constitutional difference between effective guarantees, which the evidence shows there are none.
In 2012, we said Grommet and Larkin don't govern here.
Yes, Your Honor. But
so let's not rehash it. It's the law of the case.
Yes, Your Honor, but you're required, I believe, to look at what the facts show. And I'm saying fusion does.
Are you saying that's not the law of the case? Come on, what is it you're saying?
Your Honor, what I remember of that previous decision was they said Larkin provides a standard. He says this is not a standardless case as in Larkin. And yes, Your Honor, but Grommet says they did not address the fusion that results from the commissioning of a clergy person with the power as is demonstrated by this document, this zeroing out. They did not examine zeroing out. You won't find in there any reference to Black's testimony or any of the other evidence that showed the denomination played a role. And that is the question. Effective guarantees. Guarantees.
We will not find it where in the 2018 opinion.
In the 2013 opinion, you won't find any reference to zeroing out. You won't find any reference to Admiral Black's testimony, Washburn's testimony, none of the testimony that shows that denomination played a part. So if there's an effective standard, how can denomination play a part? It does. The evidence before this court is that there are no effective guarantees. That's the standard by Grommet. That's the standard by Larkin versus Grundlesden. Now,
okay, Mr. Schultz,
yes.
I want to make sure my colleagues don't have additional questions for you before we let Ms. Soni have her time, and then we'll give you a rebuttal time.
No.
Okay, thank you, Mr. Schultz. Ms. Soni.
Thank you, Your Honor, and may it please the court. Sushma Soni for the Secretary of the Navy and the other federal defendants. I'd like to start directly with the standing questions that were posed to my opposing counsel. When Your Honors asked if there were claims that AGC had, that if they were found to have standing, that they could assert that were not already decided, the answer is no. They were asserting the same systemic claims that the other plaintiffs asserted. They were part of the original Gibson class, which filed suit in 2006. There were, at the beginning, some issues about accession. Those kind of dropped out during the course of this lengthy litigation. My understanding is that I don't want to put words in the plaintiff's mouths, but my understanding was that the claim was that accessions were allegedly took place according to that the Navy followed an illegal quota system. That was the allegation. But even if that allegation were true, and we maintain that it is not, there is no question that since the early 2000s, the Navy Chaplain Corps has accessed chaplains into the Chaplain Corps purely on the basis of merit qualifications without regard to religious affiliation, and there are no quotas. And there are not even any accession goals at this point, as far as I understand.
But that sounds like that's your merits response, which may well be persuasive. But it sounds like what you're saying is, if we had to go to the merits on the accession claims, here would be our response, and it's foolproof. And as I understand what happened, and correct me if I'm wrong, there's a long history here, and there may well have been things in the record that we're not completely processing. But as I understand what happens, there were accession claims made at the outset by AGC, and I think by individuals, but at least by AGC. And then those claims were dismissed based on a lack of standing. And then they never saw the light of day in terms of resolution of the merits. And if that's true, and if, again, just hypothetically, if we were to conclude that the determination that AGC lacked standing was erroneous, then there would be some claims that AGC had that have not yet been resolved on the merits.
Well, Your Honor, the response is that this alleged policy ended before AGC filed suit. And they are only asking for a change in the Navy's practices. So you can't get standing based on practices that weren't in effect when you filed suit. That is why the district court, when it was looking at whether AGC's core mission was at loggerheads with what Navy's policy was toward accessing individuals into the Chaplain Corps.
But weren't there were no accession claims that went past 2000?
No, Your Honor, they were talking about an alleged policy of this alleged quota system. And there is no dispute that since the early 2000s, the Navy has followed this accession policy without regard to a religious affiliation. In fact, even the process is somewhat different from the promotion and selection board process. The applications go to something called the Care Advisory Board. It's a different process.
Can I ask you this question? It's more of a practical question along these lines. If we were to conclude, again, just if, I know you resist the premise, but if we were to conclude that AGC did have standing, would you be opposed to allowing the district court to sort out what exactly went on with the claims in terms of whether there's claims that were raised at the outset that survived because they were never resolved on the merits? Because it seems like at least there's some confusion as to what exactly was raised by whom and when, and what exactly was resolved in which opinion. Would that be something that the government would oppose?
Your Honor, we would urge this court to decide this case while it is on appeal. It has gone on for over 20 years. And when Your Honor references claims made at the outset, there have been 4 different district court judges that have considered this case.
I completely understand that this case has gone on for a long time and it's gone through many judges. That's absolutely true. But there's also a statute of limitations issue, and everybody agrees now that the statute of limits was applied incorrectly. And then there's an equitable tolling question. And yes, it's in theory, the Court of Appeals could resolve that equitable tolling question. It's also quite commensurate what courts of appeals normally do in those situations, to remand to allow that to be sorted out in the district court. And if that were going to happen, then it's going back, regrettably. I understand your perspective on this, but in any event, for resolution of that.
Your Honor, I would again, and that is another point that I wanted to be sure to emphasize. We would urge this court to decide the question of equitable tolling in the first instance, because, and it is appropriate for the court. This is one of those situations where it is appropriate, entirely appropriate, for the court to decide that question in its discretion, because the case has gone on for more than 20 years. And we are talking about the particular claims that the plaintiffs want to revive are not simply stale. They date back to the 70s and 80s, so that when the first of these cases was filed in 1999, those claims were already 2 decades old. and now would be over 4 decades old. So rather than prolong this, we would ask this court to decide the question of equitable tolling. It's also appropriate because one of the things that this court looks at is whether it would be fair to the parties, and the parties absolutely fair to the parties. The parties thoroughly briefed the question of equitable tolling and fraudulent concealment in the district court at least twice. Also, it's appropriate to decide that question if the answer is clear. And the answer on equitable tolling based on fraudulent concealment is clear.
Do you think it would be inappropriate for us to remand? Is that the government's take?
Your Honor, it is a question of this court's discretion. So it is not inappropriate, but we would simply urge this court to bring these proceedings to a close.
Soni, let me ask something. The AGC's standing, pardon me, their claim for standing is based in part on the following quotation from their complaint. AGC receives financial support from its chaplains. Rejection results in a loss of AGC's resources, etc. Is there a money claim for the lost dues, as it were?
Not that I'm aware, Your Honor. My understanding is that this is a suit for declaratory and injunctive relief. I mean, setting aside the individual's claims, it is a suit for declaratory and injunctive relief to change agency practices. So,
and the things that we would have to resolve would include, I think you said fraudulent concealment, right?
Yes, Your Honor.
I think also willfulness, if I'm not mistaken. I'm not sure. There were 3 or so elements, I think, that would have to be resolved, all of which are factual in nature, correct?
Well, my understanding, Your Honor, would be that the fraudulent concealment question would be the one to decide. I have not understood it to be a question of willfulness. I mean, here we look at what the plaintiffs have alleged.
Well, you're right. It's a question of whether the Navy engaged in a course of conduct designed to conceal.
Designed to
intent
conceal.
Rather than willfulness.
Okay.
Right?
So we look at what they're...
And then the question of actual or constructive notice, on which I'm frank to say, I think your showing was rather weak, and of due diligence. So all those things we would have to resolve from up here at 30,000 feet.
Your Honor, in terms of fraudulent concealment, it is a difficult standard. It's meant to be a difficult standard. And it's not enough simply for the defendant to have set back. There has to be some trick or contrivance. And what the plaintiffs have alleged...
This matter was not, let's see, this was resolved on the ground that equitable tolling was not possible, correct?
Yes, Your Honor.
Not on the ground that it was not warranted.
That's correct.
And so would it not be open to the plaintiffs to adduce facts with regard to intent and diligence and so on?
Your Honor, they had 7 years to do that. If it's not in the record now, there's nothing additional to come out.
The district court could not accept more evidence on that. I mean, it's just the court didn't reach it. I'm wondering about that.
Your Honor, there is no need for the court to reopen discovery in this case. It went on for 7 years, off and on, 9,000 pages of documents, 20 odd depositions taken by the plaintiffs. If they don't have evidence of fraudulent concealment now, they are not going to be able to get it. And let's look at what they say constituted fraudulent concealment by the government. They say that is the hierarchical nature of the military, the fact that selection board proceedings can't be disclosed, the fact that personnel files of other people up for promotion are protected by Privacy Act. Also, there's an allegation that unspecified members of the chaplain corps leadership told plaintiffs that the proceedings were merit-based and not discriminatory. And none of that rises to the level of fraudulent concealment. It is simply not fraud for the Navy and the chaplain corps to follow federal law. There has to be something more than this.
Have
And
they
the
implicated
notion,
the
Your Honor,
Secretary's refusal to waive secrecy?
Your Honor, 613A is an absolute statutory privilege. The Secretary can waive it in certain circumstances, like as he does, for instance, when there are IG investigations, but not for civil discovery. In fact, it's a pretty clear prohibition against that kind of the fishing expedition that civil discovery turns into.
Or was the civil discovery aspect of this also a prohibition not within the power of the Secretary to waive?
Would it be within the power of the Secretary? The Secretary can waive it,
Yeah.
but
Okay.
does not waive it for civil. I mean, Congress made it clear they don't want these proceedings to be coming out in civil discovery.
Except when the Secretary thinks there's good reason.
There's a good reason to make sure that people can have a frank exchange of their viewpoints when they meet to discuss promotion of people in the military, which the chaplains are. It was also just to close the loop on this question about the knowledge, constructive knowledge, and about the fraudulent concealment in general. The notion that the Chaplain Corps was able to conceal this evidence of wrongdoing is implausible in light of the fact, which is in the record, that the individual plaintiffs, when they were up for promotion, the information of who else was up for promotion, who was on the selection board, who was chosen, that was all known. That was publicly available information. It was disclosed around the time of the selection proceedings. And obviously the plaintiffs themselves knew if they were not selected. At the same time, it's a fairly small community, the Chaplain Corps. At its peak, it was less than 900 people. People serve together. They know what other people's reputations are. They know if there is a chaplain who is spoken of very highly by his peers, if there's a chaplain whose superior officer talks him up, and they talk to each other. And that's what the consolidated complaint makes clear. The notion that under those circumstances, the Navy could have concealed this evidence of wrongdoing, it just isn't plausible. And the court doesn't need to remand to the district court to see that. I want to make sure that I address any questions the court might have about finality, because the court did ask us to address that. And often that reflects a concern by a court that there was some type of arrangement or agreement between the parties to create appellate jurisdiction. I want to assure the panel that that was not the case here. I see I am almost out of time, and we did thoroughly brief the issues in this case. I want to make sure that I don't leave you with any questions. I mean, it is very easy to get confused in this case. So for instance, my opposing counsel referred to standards for accession that included some particular standards like leadership that are not relevant to accession, but are in fact part of the promotion process. So there are many things like that it's very easy to get confused. And I want to make sure that if there are any questions that I can address them.
I don't think so. Let me double check with my colleagues. I think we understand your arguments. Thank you, Ms. Soni.
Thank you, Your Honor. We ask you the panel to affirm.
Thanks. Mr. Schultz, we'll give you your rebuttal time.
Thank you, Your Honor. First off,
2 minutes.
the declaration of Chaplain Brownlee endorsing the Associated Gospel Church is a matter of record. It's in this, and he identifies specific chaplain applicants that were rejected by the Navy despite a shortage of chaplains. And there was no excuse. They'd met all of those things and no reason was given. And so the issue of the fact that these are years and there's nothing here that's current is is incorrect. Secondly, there is asking for injunction. These processes are created administratively. And so what's administratively correct today may be changed tomorrow, and And then we go back to the way it was. We're looking for protections to make sure that denomination doesn't become a issue. Like effective guarantees is the term, which we can't just, let me say effective guarantees, not some subjective standard, effective guarantees. And the issue of tolling, the question was, why did we not know? The only record that shows that supposedly the chaplains were aware of this was an article in the Army Lawyer and a supposedly some other discussion and a local article in the San Diego paper.
Mr. Schultz, are you still seeking a remand on the tolling issue? Because it seems in your reply brief that you're suggesting we could, or it would be appropriate or fine for us to decide that issue in the first instance. Are you still maintaining that you think a remand is, are you still seeking a remand on the tolling issue?
Your Honor, my position, or our position was that you have discretion. But the burden that the defendant has to show is that and when you get to self-concealing, there has to be widely known. I don't want to go through all of the things, and that's just not here. They can't show. They have not presented evidence of any senior chaplain, anybody there at the time that said, "Oh yes, I remember Wilkins. I remember Wilkins. We had training on that." It's not there. And if that were widely known, there'd be all kinds of people that they could come and say, "Hey, here it is," which they were aware. There's nothing here. And so the idea that somehow they perceive this just because of the fact that your promotion is, let me emphasize the fact that you don't know what the other person's record. And the very fact that as Ms. Soni pointed out, the record shows that reputation, which is not in a record, is considered. And so how is that? Reputation for what? If you're a liturgical, you like people that are liturgical. If you're a non-liturgical, you prefer people non-liturgical. And so that very argument that they were discussing this goes against allowing that. Furthermore,
okay. Thank you,
these are
Mr.
secret
Schultz.
proceedings.
Let me just make sure my colleagues don't have additional questions for you since we're through your rebuttal time. Thank you. Thank you, Mr. Schultz. Thanks for your argument, counsel. Thank you to both counsel. We'll take this case under submission, and the court will stand in a short recess before we take up the third case.
Thank you, Your Honor.
This honorable court will now take a brief recess.
Thank you, Sri.
Sure.
You're welcome, Chief Judge. This honorable court is in session again. Case number 19-7139, United States of America, ex-rel Paul A. Cimino and Paul A. Cimino Appellant versus International Business Machines Corporation, a Delaware corporation. Mr. Singh for the appellant, Ms. Mundell for the Amicus Curiae United States, Ms. Stetson for the Appellee.
Good morning, counsel. Mr. Singh, please proceed when you're ready.
Good morning. May it please the court. Tejinder Singh for the appellant, Paul Cimino. This is a False Claims Act case at the pleading stage. Our complaint alleges that IBM's fraud caused the IRS to agree to a contract it would not have otherwise accepted at a price it would not have otherwise agreed to pay. The principal question before the court is whether that allegation is plausible based on the well-pled facts in the complaint. And based on three sets of allegations, it clearly is. The first is that IBM was trying to induce the IRS to sign a contract by fraud. When IBM manufactured the false compliance penalties, its goal was to create leverage that it could use to pressure the IRS into a new contract. In order for that not to cause the IRS to enter into a contract, something would have had to go wrong with IBM's scheme. And there's nothing in the complaint that suggests anything went wrong. In fact, this brings me to the second key fact, which is that IBM got exactly the deal you would expect it to get if its fraud succeeded perfectly. Just after IBM presented its fake audit report to the IRS, the agency signed a new contract. And there's a clear relationship between the lies IBM told and the deal the IRS signed. The IRS overpaid by about $87 million, which is close to the amount that IBM falsely said was owed. And the connections don't stop there. For example, if you look at paragraph 139 of the complaint, which is on Joint Appendix 38, you'll see that IBM asserted the IRS owed penalties for 2,353 of a certain license. In the new contract, IBM billed for exactly 2,353 of that license in the first year, and then 25 for each subsequent year. IBM's misrepresentations are certainly at least one plausible explanation for those charges. You can draw a straight line between the lies they told about false compliance penalties and the deal that they ultimately got.
Mr.
The third
Singh,
set of facts.
Can you draw? You said there's at least a line. Can you demonstrate that there is but-for causation between those two things?
We certainly allege it, which is what we have to do. And when you say demonstrate, I want to be really clear. This is the pleading stage. We don't have to prove the allegations. And we've alleged it explicitly and repeatedly that the IRS would not have signed this deal but for the fraud. That's in paragraphs.
Where you have specifically alleged causation in your complaint?
Sure. So the ultimate allegation of causation, you'll find it in paragraphs 31, 37, 131, and 142.
Repeat the numbers, please.
Sure. The easiest place to find this, actually, Your Honor, is if you have our reply brief on page 5 of the reply brief. All of the relevant paragraph citations are going to be on that page. And so if you look at the top, you'll see the citations to the ultimate allegation of causation. And then if you look at those bullet points, you'll see the well-pled facts that support those allegations.
What's the allegation? What's the particular paragraph that comes closest to saying but for?
Sure. So I will take you first to paragraph 31. The materially false and inflated audit findings, and this is Joint Appendix 14. Yep. The materially false and inflated audit findings presented to the IRS and IBM's representation that it would waive those penalties if the IRS entered into a new deal caused, in substantial and material part, the IRS to enter into the license when it otherwise would not have. And that last phrase at the end there is but for causation, right? And similar language appears if you go down to paragraph 131. That's about the audit findings specifically. And it says it caused the IRS to enter the license when it otherwise would not have. Paragraph 142 is about the specific promise to waive the fake penalties. And it says that caused the IRS to enter into the license when it otherwise would not have. And, you know, when you look at how closely tied the lies are to the ultimate deal, you would normally infer that it succeeded. But there is more. And this is, again, referring to the things, this is my third key set of facts, and this is the stuff in the bullets on page 5 of the reply brief. We have observations that support the inference of causation. So, for example, IBM employee Chris Schulcz, who was in the room where it happened, said that the key government decision maker was concerned and scared about the audit findings. IBM's own internal accounts of the negotiations say that false compliance charges, well, they don't call them false, but they say the compliance charges drove a large part of the deal. So they have internally booked this as something that's attributable to the penalties that they were asserting. And so you know that they played a material role, and that IBM believed they played a material role and knew they played a material role.
So on just what, can I understand one factual detail in the allegations? So when you say that the allegations say that Chris Schulcz was aware that the IRS was concerned, I think you said that the key person was concerned. And in order to bring in the key person, you're folding in paragraph, is it 5? I can't remember the exact paragraph, but so you're melding those two paragraphs together to say that paragraph 127 in talking about the IRS actually is referring not just to the IRS as an entity, but is referring to a particular person. And that's the supervisor with whom the subsequent meeting happened.
Yes, that's right. If you look at, you know, the Schulcz paragraph is paragraph 127, but if you look at that paragraph in context, both in the context of paragraph 5, but also its surrounding paragraphs, right? Paragraph 126, which is the paragraph right before, is talking about the meeting that happens with Jim McGrain, right? Where the audit findings are presented to him. And then paragraph 127 says, Chris Schulcz, an employee who was present at that meeting, said that he was concerned and scared. In context, this is clearly about Jim McGrain's mindset. And of course, it must have been at the relevant time, because the thing that McGrain is asserted to be, the IRS is asserted to be scared of, is the Deloitte findings, which were presented in that meeting to McGrain. When we're talking about the IRS here, we're talking about the decision makers who were in the room, and not just the agency in some vague, you know, undefined sense. And I think that that's really what we need to win the causation debate at the pleading stage. Again, the pleading stage. The other side can, of course, come up with their evidence about why this didn't matter to the IRS, and we'll talk about that down the line after discovery. But in terms of evaluating the sufficiency of the allegations, it's hard to imagine allegations that are more clear, and the line for finding them plausible should be relatively low, especially when, you know, this case isn't like Twombly, where the court was looking at conduct that might be innocent, might be culpable. We really don't want to open a can of worms of discovery about something that might be innocent. IBM's conduct was highly culpable. Everything that, and even they're not contesting the sufficiency of those allegations. The things we say they did wrong are wrong. You shouldn't do those things. And so I think allowing this case to move to discovery doesn't raise any of the concerns that were motivating the court in cases like Twombly.
You're saying, you jumped over your argument about a substantial factor. Is that just because the court started you with but-for causation, or can we consider that be abandoned at this point?
Oh, I wouldn't consider anything abandoned that was in our briefs. You know, we think we'll meet any standard of causation. And we think that if you believe we meet the district court standard, which I think we do, you don't have to reach the question of what the actual legal standard is. Mostly, I just don't want to make bad law on the subject in this case by suggesting that because we meet the higher standard, that is the standard. But if you're going to reach that question, for the reasons we've set forth in the brief, and I'm happy to talk about them, we think that the right standard is either to say that you only need materiality in a fraudulent inducement case or substantial factor causation.
No, I was not actually mentioning it because I thought there was anything to it.
I see, I understand.
Just wanted to see if we narrow and clarify matters.
Can I ask you a conceptual question? So if, let's suppose that but-for causation is the right standard, then if if but for causation is a necessary ingredient of a claim, what does materiality add? Because but for causation means the decision wouldn't have been made but for the consideration at issue. Materiality says, was the consideration at issue significant? If the decision wouldn't have been made but for this consideration at issue, then how could it not be significant?
I agree. If we win causation on a but-for standard, I think we win materiality as well.
But I guess I assumed you would agree because that helps you. But the way you presented the arguments in your brief, it seemed like what you were saying is there's a materiality requirement, but there's not a causation requirement. And I almost wonder whether that seems backwards, because if there is a causation requirement, then arguably there need not be. It's unclear what materiality is adding. But if there's materiality, causation still adds something. At least but for causation does, because but for causation requires that it be an essential ingredient.
That's correct. So let me just be clear about where this whole materiality thing came from. Materiality has been a subject of recent interest after the Supreme Court's 2016 decision in Escobar. And that was a case about implied certification. And the genesis of this was that the defendants worried that if you could bring a False Claims Act case based on the violation of any regulation, right, or any requirement that might be relevant to payment, it would be expansive liability. And the Supreme Court said, the way we're going to sort which regulations and violations matter from which ones don't is we're going to look at materiality, right? So in those implied certification cases, it's only the violation of a material condition of payment that's going to get you to liability, right? And so in some cases, you need that. You need to sort that out. But that's in a case where there's probably no causation. There's no causation requirement whatsoever. Right, because in most FCA cases that are not fraudulent inducement, everyone agrees there's no causation requirement.
Right, but if fraudulent inducement requires, I mean, in a normal, I guess the way I look at it is, in a non-fraudulent inducement case, there's a materiality requirement because the question is whether the claim is false. There's no causation that attaches to that, but it still has to be material because you wouldn't want to give effect to something that's false, but it's trivial. But in a fraudulent inducement case, the very notion of fraudulent inducement requires inducement, which means, at least I know you disagree with this, but it at least arguably requires causation. And then once you have causation, query whether materiality is adding something to the causation in an inducement case.
I don't think it does. I think that once you have causation, you basically have materiality plus. I read materiality to mean potential causation, maybe likely causation. But once you have actual causation, you've crossed the bridge, I think.
Okay, if my colleagues don't have any further questions, then we'll...
well, I guess I did have one, if I may.
Sure.
So, but I think, is it fair to say then, Mr. Singh, that your contention about plausibility, if it comes down to, or at least entails, the plausibility that that the government contracting parties were intimidated by the prospect that they might be sued and agreed to a contract that they would not otherwise have agreed to, but for the threat of being litigated, that there was, I believe it was also true that they must not have looked at information that was in some column of a spreadsheet that was not emphasized to them. And just went along with this because they were personally, these two or three individuals were scared that the agency could be sued.
I'm not completely sure that I understand the question. Our allegations certainly encompass some of those facts that you've said. What I would say is when you ask what we have to show as a matter of law, I think what we have to show is that the IRS behaved the way it did because of the defendant's conduct. That is, had the defendants not lied about these penalties, had not threatened to sue, had not offered to waive them if they accepted a new deal, the deal would not have been consummated as it was. What I don't want to give the impression is that we have to win all those things, right? If any aspect of the defendant's conduct is shown to have caused the IRS's conduct, I think the IRS to sign the deal, and that conduct is fraudulent, I think we're good. And so it may be, as I said, the subjective motivations, it may be that they were scared. We've got an allegation to that effect. But even if it shows that they were worried about litigation only, but they thought they might win, we think that's still enough, right? So I just want to make sure that I'm clear about what I'm answering.
So you're portraying a government contracting process that is so sloppy or capricious that a couple of people being worried about being scared causes the government to enter into a $250 million arrangement.
I do think that there's an argument that the IRS was not terribly sophisticated in this contracting process. And if notice we cited in our reply brief, and this is mentioned in the complaint as well, there was an investigation. Congress had hearings about the IRS's IT contracting process specifically that found it to be vulnerable to fraud. But I'm not trying to blame the government here. What I'm saying is that the government's contracting folks generally do not assume that their contractors are going to just lie to them, right? They tend to take statements that are made by contractors at something close to face value. And that's in part because there are lots of protections, including the False Claims Act, that protect the government when the contractors do lie. And so while I think it's almost always the case in every government contracting fraud case that had the government been more vigilant, it might have been able to find something that would have allowed it to escape the bad deal. I don't think that that's how our society and Congress and the False Claims Act look at these issues at all. And I'm not trying to insinuate that the government was bad here. What I'm trying to say is that they were lied to, and the lies are the most clear and plausible explanation for why they did what they did.
And the lies were told to the frontline contracting party and his supervisor. Anyone else? Does the supervisor, do you allege that the supervisor had the sole authority to sign off on the deal?
I don't know if that allegation is in the complaint. I believe that that is a true fact, but I don't know if that allegation is specifically in the complaint. We say that Jim McGrain was the head of software acquisitions and was in charge of this deal. I don't know. I believe he may have had to consult with the actual chief information officer, but I don't think that's in the complaint, and I wouldn't want to speak out of school.
Thank you. Thank you.
Thank you, Mr. Singh. We'll hear from the government.
Good morning, Your Honor. May it please the court. My name is Amanda Mundell on behalf of the United States. This court should reverse the district court for two main reasons. First, because it erred with respect to its causation analysis, as Mr. Singh has discussed in some detail, and also because it erred in respect to its materiality analysis. And just with respect to causation, I want to make clear the government's position here is that at a bottom line, the district court's conclusion that but-for causation is required, we do agree with that. We also agree that this court doesn't need to decide that issue itself if the court concludes that the allegations of the complaint properly establish and plead but-for causation. But we do have some concerns with the path that the court took to get to that conclusion. And so to the extent that this court is going to reaffirm the continuing validity of the fraudulent inducement theory, as we think that it should, we would just ask that the court not introduce any ambiguity or imprecision that we find inherent in the district court's opinion. In particular, we think that the court, in trying to reach this but-for causation conclusion, seems as though it was reaching for something beyond what is typically required in a fraudulent inducement case. And that is to say that courts have long recognized this as an established theory of liability under the False Claims Act. And no court, not the Supreme Court in Marcus versus Hess, or this court in Bettis, or any other court of appeals, has really struggled to either parse out the elements of fraudulent inducement or struggled to apply them in the way that the district court did here. And when the court did announce but-for causation, it then took the extra step to say, but even that level of causation, quote, understates the stringency of the FCA's causation standard. And so we have some concerns that the court was sort of looking beyond what is typically required in the fraudulent inducement context to establish but-for causation, and then resorting to various cases that are inapposite, like in the damages context, to shore up that analysis. And here, really what was required is exactly what Mr. Singh has discussed with this court in his opening argument, which is that had these fraudulent statements not been made, had the trumped-up audit findings not been presented, and the false promise to waive the $91 million penalty not been made, the government wouldn't have entered into this contract. That's pleaded explicitly in several places in the complaint. And then there are several allegations, as Mr. Singh highlighted, that make that allegation plausible. The fact that the IRS wasn't thinking about renewing this contract to begin with, that the $91 million compliance penalty was at a pain point sufficient to force the government to enter into this, quote, compliance deal, that the IRS is, of course, concerned or scared of these audit findings. And then, of course, it would not have entered into the license had it known that those representations were false. So we think for those reasons, not just did the district court misapply this inducement element to the allegations of the complaint, but really it sort of overcomplicated needlessly the inquiry there. With respect to materiality, though, we think the district court erred in two main areas. First,
can I just ask you the same conceptual question? If we buy your argument that there's but-for causation as a requirement, what does materiality add because even in your brief, when you explain why materiality is adequately pled, you just basically rely on what was explained with respect to but-for causation. And I guess conceptually, it seems like but-for causation means that the consideration at issue is essential to the decision. Materiality asks, is the consideration at issue significant to the decision? And I get that there's a different temporal reference point, that materiality comes ex ante and but-for causation comes ex post. And suppose maybe somebody could conjure up the hypothetical that makes use of that temporal distinction. But as a real world matter, in the mine run of cases, does the government think that materiality adds something to but-for causation in the fraudulent inducement context?
No, Your Honor, and Your Honor is correct. It's very hard to imagine, if not impossible to imagine, a scenario where if but-for causation is established here, that then the allegations would somehow fail on a materiality aspect. At the end of the day, if the government wouldn't have entered into the contract absent those fraudulent statements, we know that those fraudulent statements were important or significant to the government to establish materiality. That's just a feature of fraudulent inducement as a theory of liability that isn't present in these other typical FCA, false statement submission cases,
which are governed by Escobar, where the court explained the significance of materiality.
Exactly right, Your Honor. And so here, the reason we've sort of split up our analysis is just because that's exactly what the district court did. It sort of parsed out these elements as separate pieces, when really what satisfied but-for causation in this complaint certainly satisfies materiality. And there's one other point that I would make with respect to that materiality point, is that when doing that assessment, in addition to failing to conduct that holistic analysis, the court did make reference to the government's declination decision in this case not to participate. And we think this court should hold that that is simply not relevant at the materiality stage, because there are many reasons, non-merits wise, that the government might not participate. And it certainly doesn't give any information about whether the government thinks that a statement is material or not.
So is it not entitled even to some respect, as the district court said? You think it's just simply irrelevant?
That's exactly right, Your Honor. And that sort of makes sense for two reasons. One, we know that False Claims Act allows for relators like Mr. Cimino to bring these claims without the government's participation. And so it would be very odd if courts could take into account the government's declination decision as a reflection of materiality and make it even incrementally more difficult for a relator to bring those suits. And then secondly, of course, it simply ignores the realities of the government system, which is we simply cannot participate in every single False Claims Act case and all the other cases that we litigate in this country. And so the fact that the government doesn't participate doesn't necessarily mean that it's a comment on the merits. It could be a resource-specific problem. And it certainly doesn't mean that even if it's a merits-related decision, that it's a comment on materiality, as opposed to some other aspect of the case that's sort of difficult to discern at the pleading stage. Your Honors, unless there are other questions, we just urge that this court reverse.
Thank you, Ms. Mundell.
Thank you.
Stetson.
Good morning, Your Honors, and may it please the court. My name is Kate Stetson. I represent IBM. I'm going to start actually where Mr. Singh did, which is that this is a False Claims Act at the pleading stage. But what that means, I think, is significant, because as we know, after Twombly, Iqbal, Escobar, the pleading stage has some teeth. And there are a few basic factors that I think are relevant here. One of them draws on Judge Rao's first question, which is that it's not enough at the pleading stage to allege conclusions. You have to allege facts backing up those conclusions. And you have to allege those facts as being more than consistent with the prospect of liability. They actually have to point towards liability. In response to one of the questions Judge Ginsburg raised, this court under Iqbal is also instructed to take its common sense and experience into account when it's reviewing a motion to dismiss and the allegations in a complaint. And then, of course, there's a third thing that I don't think has come up at all yet in the argument, which is that a fraud plaintiff, including a False Claims Act plaintiff, needs to satisfy Rule 9b. So that's the additional test that these allegations need to be put through. So I want to pick up Chief Judge Srinivasan on your question about causation and materiality, because I do think as a conceptual matter, they tend to collapse into each other in a case like this. But I want to offer one view on how materiality could work as a backstop in the analysis, and that is essentially with reference to what the district court did. There are many cases at the dismissal stage, D'Agostino, Nargal, Petrados, Sanford Brown, to name 4, that find that a representation to the government could not have been material when the government continued to pay on the contract. So I think while conceptually, when you're talking about the point at which you're reviewing this, Chief Judge Srinivasan, you made the point about the temporal difference. That temporal difference kind of gets erased with the passage of time. But I think where materiality, where that analysis is helpful, is in this court testing, kind of the conclusion against the facts. So, what this court said in McBride is, since we have the evidence available to us, we might as well make use of it, essentially. And what we know in this case, and what the district court held, and I want to be very clear about this was not some kind of singular, non-holistic materiality overview. This was a multi-step commentary, which it then capped off with a reference to declination. And I want to be clear on that as well. I'll get to that in a moment. But when the district court talked about materiality, and you can find this at Joint Appendix 416 to 417, it made a few different observations. One was that the IRS paid all or a substantial portion of the fees, as even the complaint alleged. And most of those were paid after the case was filed. And you can cross-check that against Joint Appendix 320 and 336, which set out the schedule for payments. The IRS agreed to add 6 months to the contract. It took the contract out to its maximum time under the available contract. That's at Joint Appendix 336 as well.
Stetson, excuse me. Wasn't all of this occurring while the government was considering whether to bring a case?
It was, and I think that's a point that Mr. Cimino makes in his briefing, is that these were just allegations rather than actual knowledge, as was the court's quote in Escobar. But I would respond that in Petrados, in Sanford Brown, in McBride, and I think in D'Agostino, all the courts had there was allegations. And the 10th Circuit in Jansen actually answered exactly this question.
I'm interested in a separate question or different inference. If the IRS, pardon me, if the government, if justice receives the information suggesting there may be a case here, and it investigates that, surely it must tell the IRS, or if the IRS asks, must say, look, just keep on paying on the contract. We haven't reached a decision, and because we may not bring a case here. Indeed, we may conclude it's fine. We just don't know. So you have no basis for just stopping payment in the middle of the contract.
Well, I don't, first of all, that's certainly not an argument that Mr. Cimino has offered here. But second, more to the point.
No, it's a question about an argument that you're making, that there's somehow significance to the IRS continuing to abide by the contract.
Yes, my point is that Mr. Singh hasn't alleged that the IRS was somehow hamstrung from stepping out of the contract.
Well, I'm not saying they're hamstrung either. I'm saying that it would be, it's a peculiar point for you to be making. It's not persuasive because it would require the IRS to have stopped paying on a contract that the Justice Department had not concluded was fraudulent.
Under the regulations that govern this contract, Judge Ginsburg, and you can find this at Joint Appendix 320 and the references to the regulations there, the IRS could terminate this contract for convenience. So it didn't need to wait around for the government to tell them whether there was some massive fraud that had been operated on it. And more to the point,
but what would be more inconvenient than terminating the contract in the middle? I mean, the idea that it would be convenient for the IRS to stop paying and lose the benefit of the services in the contract.
Oh, no, I
quite beside the point.
I hear your point, but I don't think that's what terminating for convenience means in government contract speak. I think what it means is at the IRS's election. So it may well have been.
But even if it's at the IRS's election, if they terminate, they don't get the services anymore, right?
That's correct. Yes.
So from their standpoint, I think an IRS could conclude there may well be something nefarious going on here. We haven't completely figured it out yet, but it would actually be inconvenient for us to lose the services right now in the middle of tax season. Or I can't remember exactly when this occurred, but it would be inconvenient for us to stop the stream of services.
Well, the IRS would have had to conclude that in 2014, 2015, 2016, and 2017, and then, of course, with the extension that it tacked onto the contract. So there is a point at which I think if we're going to engage in this hypothetical, that the IRS could have made it convenient to them simply by contracting with somebody else. And this, after all, was not, this is not the kind of line of thought that the court thought was significant in any of the other cases that I've mentioned. Petrados, D'Agostino in particular, those involved actual allegations of bad drugs and bad devices on the market. And I don't think that it would have been the case that an agency would have thought, well, I need to wait and see how this DOJ investigation shakes out before I take this bad drug off the market. The IRS had the independent authority to end this contract if it chose to, and it didn't.
Is there any reason to think in the record that it was dissatisfied with the contract?
No. There's no evidence in the record to think that it was dissatisfied with the contract. That's actually one of our points, is that it continued to renew the option years, 2014 through 2017.
I think it's irrelevant either way, frankly. I mean, the idea that somehow they attach significance to what the IRS did or didn't do when the matter is up in the air strikes me as mistaken on both sides.
Well, I take your point. I think I would say that among the other notes that the district court drew from this set of facts is that one thing we might think is that if the IRS had been overcharged by $87 million, that the IRS would have sought return of that money. And I don't think, and Mr. Singh hasn't alleged, that it was somehow precluded from seeking return of that money until the DOJ finished its investigation.
I mean, at this point, all we're trying to figure out is whether the allegations in the complaint are sufficient, right? I mean, I think a lot of things they're saying presumably will be brought out and might well be persuasive at the end of the day. But in terms of what's in the complaint and gets past the pleading stage, I'm curious about your reaction to paragraph 127, the one about Chris Shum. And it just says you're talking about a particular IBM employee. So it's not a generalized allegation. It's pointing at a particular individual in a particular context, the exchange they had with the supervisor. And it specifically relates to the Deloitte findings. And it says that Shum was aware that the IRS was very concerned. And that just seems like that's a fact that goes to materiality. Very concerned seems material. It seems like a reasonable facsimile for material. And it's a specific individual who was aware that the relevant decision maker was very concerned. Is that not enough?
I think Mr. Singh is using that paragraph to support both his materiality and causation arguments. Yeah. I would urge the court to look at that paragraph, not the characterization in the opening brief or the reply brief. Here is what that paragraph says. Mr. Shum was at the meeting. During the course of his employment with IBM, Mr. Shum was aware that the IRS was very concerned and scared. Now, what that has morphed into by the time of the reply brief is because he was at the meeting, Mr. Shum was aware that Mr. McGrain was concerned and scared. That is a bridge too far in terms of inferring from that broad, vague statement and one paragraph of the complaint. If Mr. Shum had been at the meeting, if Mr. Shum thought that Mr. McGrain himself was concerned and scared, and to Judge Ginsburg's point, that Mr. McGrain even had authority to sign off on a $250 million contract in the first place, you would think that would be in the first amended complaint.
Well, just to pinpoint exactly what the allegation must be dealing with, you're right to say it says during the course of his employment. And so in some sort of abstract sense, it could have been, I don't know how long Schulcz worked there. Let's say he worked there for 50 years. It could have been at some point in the course of his employment. But what he was concerned and scared about was the false Deloitte findings. That's what the allegation says. So it particularly relates to the very falsity that's the gravamen of the complaint, which is temporally confined. Right, it's a finite point in time. It's the particular Deloitte findings, and it has to do with the very meeting. I'm not even sure that this allegation is necessary, but in terms of whether it's sufficient, it seems like it's pretty detailed about a particular employee having a particular concern about a particular falsity.
I think it is certainly not sufficient. It's necessary to Mr. Singh's argument because this is the hook on which he hangs everything else. All of the other paragraphs that Mr. Singh mentioned in response to your question, Judge Rao, are legal conclusions. Paragraph 31, paragraph 131, paragraph 142, all of those are IRS would not have done this but for X. So what he needs is the thing that shows that linking concern, and simply saying that an employee was aware during the course of his employment that the IRS was scared of the audit. First of all, that's far too general. And second of all, to make the point the district court did, being concerned about the audit doesn't take that last necessary step to show that the IRS actually accepted the results of the audit. And we actually know from multiple details in the complaint that the IRS had repeatedly rejected the audit before it came to this December 19th meeting. So I think you have to blink away a lot of other signals in the complaint that Mr. McGrain, the supervisor of Mr. Kravitz, who had already rejected, excuse me, for lack of substantiation, the audit results on two separate occasions, that Mr. McGrain would have been so hornswoggled by this that he would say, I'm terribly frightened of this audit. I'm not going to ask about the assumptions that underlie this audit. I'm not going to check with Mr. Kravitz, who presumably is not somewhere who's unreasonable.
I'm sorry, I cut you off. Go ahead. Finish that thought, please.
No, please go.
Don't you have to also blink away, though, in pointing the other direction, what IBM was doing? Because, I mean, the entire point here of IBM's scheme was predicated on the idea that the $91 million would matter. And it seems like you have to sort of blink that away, just in terms of the allegations and complaint. I'm not suggesting what's got to be proved at the end of the day, obviously, or even whether it gets past summary judgment, of course. But just in terms of getting past the complaint, the entire object of IBM's scheme was predicated on the idea that this was going to matter. And it seems like you need to blink all that away, too, to read just the allegations in the complaint in the way that you do.
But it can't be enough, Chief Judge Srinivasan, to argue that IBM thought this would matter.
It may not be enough, but boy, IBM's a sophisticated enterprise. I mean, if based on the allegations, they went to all this work to try to make sure that the IRS was going to continue the contract because the IBM, at least one employee thought the IRS was very concerned about it. That suggests that IBM would have had to have been pretty darn wrong about something that it understands pretty darn well.
Well, I think the allegations in the complaint show that IBM was pretty darn wrong about its audit when it was rejected twice for lack of substantiation by Mr. Kravitz. So IBM's intent, under the facts of the complaint, which we have to allege or we have to accept as true at this stage, the facts that are in the complaint was that IBM was very determined to put one over on the IRS. What's missing from the complaint is any suggestion that the IRS, the person responsible for signing that, who, as Mr. Singh conceded, we don't even know is Mr. McGrain, that person accepted the audit results and that led to the signing of the contract. That is the missing big plank in the bridge that they're missing for causation purposes. And the reason that matters is because, particularly in a fraud case, where we are asking all fraud plaintiffs, including this relator, to plead with specificity, simply saying there was a guy who was in a meeting who worked and during the course of his employment, he got the impression that the IRS was scared of this audit. That can't possibly be enough to satisfy Rule 9b. I don't think it satisfies Rule 8. But when you add that additional layer of rigor, if that is the paragraph that we're talking about, then that is completely insufficient.
Thank you. I'll make sure my colleagues don't have further questions for you. Thank you, Ms. Stetson.
Thank you.
Mr. Singh, we'll give you rebuttal time.
Thanks. I'll just talk briefly about 2 points. The first is this question of continued payments. And Judge Ginsburg, I think your insight that it's not relevant is exactly correct at this stage. To draw any inference from continued payments when the validity of the contract has not been adjudicated would be a mistake, and especially so at the pleading stage. Ms. Stetson mentioned a number of cases. One of the ones she said had only allegations, the McBride case, was of course at summary judgment. We talk about that case in depth in our brief, and there were a litany of facts weighing against materiality. The other cases she talks about, some of them were at the pleading stage, Petratus and D'Agostino. We've addressed those in our brief as well, and they involve some peculiar considerations relevant to the FDA, but also there was substantially more in the complaint itself about what the government knew about the allegations, and that just isn't here in this record. So again, as a matter of adjudicating the pleading stage, I think it is, you would have to draw a strong pro-defense inference about materiality, which is just something you're not allowed to do. All the reasonable inferences go our way at this stage of the proceedings. The second point that I would talk about is this question about the Chris Shum allegations and just what's necessary. And Judge Srinivasan, I think you're right that you have to blink away that IBM was trying to get away with this. And you also have to blink away that really the proof is in the pudding. The deal has the fraudulent charges in it. The thing that IBM was trying to get the IRS to do, to believe, was that it owed these charges. Why would the IRS have paid an extra $87 million if it hadn't been convinced that it was required to do so? And so once you take that fact into account, there really is no plausible explanation for why this deal went down the way it did, other than fraud. But that's not the standard.
I don't have to
eliminate every other.
Mr. Singh, what about just government negligence or oversight?
Sure.
I mean, it's a lot of money, but there's a lot of money in government contracting.
Your Honor, I think that if we are, even if you, so two things about that. First, I don't have to eliminate every other plausible explanation. I just have to show that we have one of them, and we have one. The fact that IBM said you owe these penalties and then the IRS wound up paying these penalties is pretty good evidence that the IRS was convinced when previously it didn't believe it owed that money. But even if you're right, the explanation you're positing of negligence isn't a defense for IBM. You don't get to defraud the government because you think they're not going to catch you. That's not how this works, unless the IRS on its own initiative believed that owed these monies without any input from IBM. You would not say that this is exculpatory. And there's no way that you could look at our complaint and say it alleges that. And so at the pleading stage, I just don't think that there's any way for that to be the kind of obvious alternative explanation, to use the Supreme Court's language from Twombly, that would eliminate liability in this case at the pleading stage. Unless the court has any other questions, I'm grateful for your time. Urge you to reverse.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
This honorable court is now adjourned until Tuesday, October 13th at 9:30 a.m.